Have you ever wondered what actually happens when a lawyer, someone sworn to uphold the law, breaks the rules? I mean, it's not like they just get a bad performance review. There's this whole intricate system for investigation and discipline. Today, we're going to pull back the curtain and walk through exactly how that system works, using Missouri Supreme Court Rule 5 as our guide. So here's our roadmap. We're going to start with who's in charge, the guardians of the system. Then we'll follow the life of a complaint, from the first whisper of a problem to a full-on investigation. We'll look at the off-ramps, ways to resolve things early before getting into the serious stuff, the formal hearings. And finally, we'll cover the consequences and the incredibly tough path a lawyer has to take to get their license back. All right, let's dive right in. First things first, we need to meet the key players. You got to understand, this isn't just one person making a call. It's a whole structure of committees and councils all set up to keep things fair and, most importantly, to protect the public. These are the four main pillars holding up the whole system. You've got the advisory committee, which is kind of like the board of directors looking at the big picture. Then you have the regional committees doing the initial legwork. The chief disciplinary counsel, think of them as the lead prosecutor. And the disciplinary hearing panels, well, they're basically the judges in this very specific world. Now, here's something that I think is absolutely fascinating. Take a look at who's on these committees. At every single level, they intentionally include non-lawyers. That's so important. It ensures the system isn't just a bunch of lawyers judging other lawyers behind closed doors. It's designed to bring in an outside perspective and maintain public trust. Okay, so we know who's in charge, but what happens when a complaint actually gets filed? Let's trace that path from the moment an allegation is made to when a formal investigation kicks off. It usually starts with a complaint, right? But here's a twist. Under Rule 508, the Chief Disciplinary Counsel can actually start an investigation even if nobody files a formal complaint. If they see or hear about potential misconduct, they can just go. From there, the investigation is all about finding out if there's probable cause. Basically, is there enough smoke to suggest there might be a fire? But there is a ticking clock here. For most cases, an investigation has to be launched within 5 years of the misconduct being discovered. Now, there are exceptions. For really serious stuff like felonies, that clock doesn't apply. So after that initial look, the whole thing comes to this massive fork in the road. If the investigators decide there isn't enough probable cause, the case usually gets dismissed. But if there is enough evidence, the case moves ahead, and that lawyer is looking at either a formal warning or some serious charges. Now, not every case that has probable cause goes to a full-blown dramatic hearing. The system actually has these built-in off-ramps for less serious issues. The focus here is more on fixing the problem than on pure punishment. The first off-ramp is something called diversion. You can think of it like a corrective action plan. For a minor mistake, a lawyer might agree to, say, take an ethics class or have their practice monitored for a while. If they do it, the case gets closed. And here's the key. It is not considered formal discipline on their record. But, and this is a big but, diversion is strictly for the small stuff. The rules make it crystal clear. If the problem involves stealing from a client, lying, committing serious crimes, or if it's part of a bigger pattern, well then this option is completely off the table. No second chances there. The next step up is an admonition. This is, for all intents and purposes, a formal slap on the wrist. It's a written warning. The lawyer gets a choice. They can accept it and it becomes a public part of their record, or they can say no thanks and decide to fight the formal charges instead. So what happens when the misconduct is just too serious for one of those early exits? Or what if the lawyer just flat out rejects that admonition? Well, that's when things get very, very real, and the case moves on to a formal hearing. The whole thing kicks off with a formal document called an information. The absolute easiest way to understand this is to think of it like an indictment in a criminal case. It spells out in black and white exactly what the lawyer is being accused of doing wrong. And this is where that disciplinary hearing panel we talked about earlier comes into play. It's a 3-person panel, and again, notice one of them is a non-lawyer, and they act just like a court. They listen to evidence, they hear from witnesses. It's a trial, and their job is to decide if it's more likely than not that the accusations are true. After everything is said and done, the panel writes up its decision. But here's the really important part. That decision is only a recommendation. They recommend either dismissing the case or giving the lawyer a specific punishment. Both the lawyer and the chief disciplinary counsel can then accept or reject it. And if either one of them rejects it, The whole case goes all the way up to the Missouri Supreme Court, who gets the final say. So if a lawyer is found to have broken the rules, what are the potential consequences? Well, the punishments run on a pretty wide spectrum, from what amounts to a public scolding all the way to losing their license to practice law forever. You can see how the sanctions climb in severity. A reprimand is the lowest level, a public censure. Then you've got probation, where a lawyer can still practice, but under really strict supervision. More serious is a suspension. Their license is taken away for a period of time. And the ultimate penalty? Disbarment. That means their career as a lawyer is over. And on top of all the professional fallout, there's a direct hit to the wallet. Lawyers who are disciplined have to help pay for the cost of the investigation. And as you can see, that cost goes up depending on how severe the punishment is, from $750 for a reprimand all the way to $2,000 for disbarment. So for a lawyer who's been suspended or even disbarred, is that it? Is their career just done? Well, not always. But the path to getting a law license back is incredibly steep and demanding. Which brings us to the million-dollar question, right? Is there a way back for a lawyer who's lost their license? Can they ever get a second chance? The answer is yes, it's possible, but it is anything but a guarantee. Rule 5.28 basically lays out an obstacle course. A lawyer has to prove, with clear and convincing evidence no less, that they are fit to practice again. That means paying back anyone they harmed, passing a tough legal ethics exam, getting caught up on their education. Oh, and for anyone who was disbarred, they have to go all the way back to square one and pass the entire bar exam again. Wow. And all of this brings us back to the fundamental question. From having everyday people on the hearing panels to that incredibly high bar for getting a license back, this entire system is a balancing act. It's trying to hold lawyers accountable and keep the public safe, while also leaving the door open for due process and rehabilitation. The real question is, does it strike the right balance?